Hello and welcome to Maine Law Matters, where we interview people who have been important to Maine law, to the Maine legal community, to the state of Maine, and to our country. I'm Lee Softly. I'm currently serving as the president and dean of the University of Maine School of Law. It is May 29, 2026, and it is my honor this morning to interview former Chief Justice Daniel E. Wathen. Dan, welcome to Maine Law. Welcome to the Godfrey Reading Room. And my inclination is to call you Chief because you are always my chief. But I'm going to suggest we go with first names today, if that's all right with you.
That's fine with me.
All right. Okay. So let's start at the beginning, because you used to tell us wonderful stories about Aroostook County, growing up there, right. What brought you to Ricker College. Tell us a little bit about your youth, misspent as it may have been.
Yes. Well, I grew up in Aroostook County in a little town called Easton, which is 1,300 souls. And everybody knows everybody, and you can't get away with anything in a small town. And I was a perfect student through the 8th grade, and then I sort of branched out into more rebellious ways in high school, and went to college at University of Maine and the reason that I got in was not because of my grades in high school. I think I graduated 16th out of a class of 17, but I always did well on standardized exams, so that I got into University of Maine. But I had never studied and never taken a book home in my life. And obviously, if you don't read the books, it's kind of hard to do well. So at the end of the first semester, they said, perhaps you ought to take a year off and come back and try it again. And so I did. It wasn't an option. They just said, you're done for the time being. And I went back, and a fellow came up that knew my family and said, why don't you go to Ricker College? And I said, okay. So I went to Ricker College, but nothing much had changed. And I didn't do very well there. I guess I got through the second semester. And the next year I just quit halfway through. The only thing that I took a test in was art appreciation.
And did you appreciate art?
Yeah, I was very good at art appreciation. So my record for the first 2 years was, and I went to Florida and worked in a used car lot. So that was my...
You went to Florida?
Oh, yeah, yeah. I came back from Florida and went to work. One of the things in a small town, there was always work available. You had to hide if you didn't want to work, because there was always a farmer coming looking for a dirty job that they wanted you to do. So I came back from Florida, and I was put down in the cellar of a burnt potato house, shoveling out rotten potatoes with the fruit flies flying up in my face. And I thought, this isn't very good. So I got a job shoveling fresh potatoes, which was a step up. But in any event, my mother said, are you going back to college? And I said, well, I have to. She said, have you ever thought of... I had my girlfriend, Judy, we'd been going together since freshman in high school. She said, have you ever thought about getting married? And I said, no. I said, I can't support myself, much less a family. She said, well, I'd be happy to support you if you did something in college. And I said, well, maybe that will work. So 2 weeks later, we got married at 20 years old. And I went back to college the next year.
Back to Ricker?
Ricker. And from that point on, I was a Dean's List student. I actually started reading the books, paying attention, and attending class.
It has a wonderful palliative effect, doesn't it?
Yeah, it was really amazing what a difference that made. And so I became a Dean's List student, and at the end of that, there was a history professor that wanted me to go to Michigan State to do a PhD in history. And there was an economics professor wanted me to do a PhD in economics. And I was afraid, I loved economics, but I was afraid of the math because math was not my friend. And so I was all signed up, had a scholarship to Michigan State. And my brother, who was a lawyer, came along and said, "Have you applied to law school?" And I said, "No." I said, "I don't have any money," which was a lie. But he said, "I'll pay for the application fee." And he said he wanted me to go to D.C. because that's where he went, in American University. And I said, "I'm not going to D.C." And he said, "Well, the University of Maine is just starting up this coming year in Portland. And why don't you apply there and I'll pay for the application?" So I did, and I was admitted. And
that was the very first class of what is now Maine Law.
Yeah, Ed Godfrey had come the year before, but it was not, he was there preparing for this. And so this was the first class that was admitted under the rule of the new University of Maine. And Ed described it later on that he said, when we looked at Dan's application, it was difficult. He said it appeared that he had done nothing for the first 2 years. And then he experienced an epiphany. And we went with the epiphany. But the other thing was, I had a high LSAT. The old standardized
that'll do it every time.
Saved me again.
It still saves many of us along the way.
Right.
So let me ask you about that first class. It wasn't large. Were there any women in the class?
There were no women in any of the 3 classes. There were 2 classes ahead of us that were under Portland University, or Portland Law School.
Right.
And they were a little bit larger. Our class was 10, and then there was probably 12 or 14 in each of the classes ahead of us. Joe Brennan was a 3rd-year student when I was there.
Wow. No women at all?
No women in the entire thing. And there was only, to my knowledge, there was only 2 women practicing in the state of Maine. And the first woman admitted as a student was in my 3rd year, and she was admitted into the 1st year.
So she was not in any of your classes.
No,
you graduated, the school was accredited,
right,
and you went off to practice.
Right.
I remember having conversations when I first came to the law court with you about how you got to Maine Law. Were you thinking of being a lawyer in 4th grade? To which you responded with great humor, as I recall. 4th grade, you were not thinking of being anything near a lawyer. In fact, what I recall is you were explaining to us that you were anticipating the life of a felon until something happened and you were able to buckle down again. And now I understand it's rotten potatoes that urged your wonderful student work.
Well, plus
and
marriage. Marriage, yeah.
And
I don't
marriage.
recommend marriage as a cure-all for anything, but it fit my situation. And my mother was correct. She knew that
would settle you down.
She didn't say that, but she said, "Well, I'd be happy to pay for it
if you got it.
If you do something."
We all knew Judy was a saint. She kept you on the straight and narrow.
Right.
Let's go fast forward for a moment. You went into practice in Augusta, or did you start in Augusta?
I did.
At Pierce Atwood?
Yeah. I had a job offer here in Portland, and I also had the bankruptcy referee had offered me a position as a law clerk for him. And my brother was practicing at the time. My older brother, he's 12 years older than I was practicing in Augusta in a firm that pretty much he was one of the beginners of the firm. And I had worked there 2 summers during law school. And so I naturally gravitated towards that, or at least it seemed natural. And so I started practicing in the fall of 1965. We, at that time, did pretty much everything. The only thing we didn't do was debtor bankruptcy. We did Chapter 11 corporate stuff and that sort of thing.
Did you do any criminal law?
Did a lot of criminal law at the beginning. A judge told me that Jim Reed was a Superior Court judge, great judge, and he told me that if you're going to be a trial lawyer, you got to do about 25 cases. It doesn't make any difference what they are, just to get the experience and the confidence of being in the courtroom. And so I did a lot of court-appointed cases that came along, and in those days you could get all of those you wanted. And we did insurance defense work and plaintiff's work, which was common at that time to do both.
So you had a lot of jury practice.
A lot of jury practice. And then the other unique thing about our practice was that we also did a lot of transactional work, because my brother represented the Maine Industrial Building Authority, the Maine Recreational Authority, which what is now all of these agencies are under FAME, but in those days they were independent, and they had private counsel. So
I love the idea that you need 25 cases under your belt to get the rhythm, to understand the choreography, and were there particular cases that you liked more than others, or did you just love getting into the courtroom?
I just loved getting in the courtroom, and I used to go down. For example, I knew that they always have, as you know from your trial work, when you get a list of cases as a judge, half of them don't want to go to trial. They want anything but trial.
Exactly.
And so I used to go down to the district attorney and talk to the lady who did the scheduling and say, look, here's my cases, these are the criminal ones. Here are my cases. I'm ready to try any and all of them. And just tell me when you want me here. And she loved it, because
she could just put you on a list.
Yeah, and so I would, when it started out, I would probably try 3 or 4 cases right off the bat. And some of them I tried several murder cases and a lot of crime. And
a very different world from today, where you have to work your way up to and demonstrate that you've second seated, and it's very different.
Yeah, no, it was just you go in, that was it. And the district court was where you got started.
Yep.
And you, literally, I was admitted in September, and the very first day after the admission, I appeared in Waterville District Court, court appointed for a guy who had spent 12 of the last 14 years in county jail. He was sort of like in Rumpole they have the Timpson family. Well,
it was the Timpson family of Kennebec County.
This was the Timpson family. There was a point in the proceeding, it was a little complicated, but I moved the misdemeanor over to Superior Court. The client spoke up and said, the judge said, what do you want to do? There was a felony and a misdemeanor, and I've forgotten the details, but the judge says, what do you want to do with the misdemeanor? And my client spoke up and said, we'll waive hearing and take an appeal, which was how you avoided having the trial. And the judge, this was Judge Poole, and you'll remember,
oh,
he's a great judge. He's a great judge. And he looked at me and he said, is that what you want to do, Mr. Wathen? I said, yes. So Larry, the defendant, went through our career, and I represented him many times and many members of his family. And he said, I taught Dan how to practice criminal law, which was an element of truth to it.
He was very experienced by the time you arrived.
I hadn't learned how you get rid of a misdemeanor without pleading guilty to it in district court or having a trial.
So when you were doing the trial work, you were working in that beautiful Superior Courtroom in Kennebec County that, thank heaven, we've been able to preserve, and that's where most of the juries are being still done there. It's such a beautiful courtroom.
Yeah. No, I loved that courtroom. But I also loved Lincoln County. There's sort of like a Shaker simplicity.
Yes.
Yeah.
So you then had lots of experience with trial work. Were you were you interested from the beginning in going to the bench, in becoming a judge, or did that just happen as the governors started looking for good and experienced trial attorneys?
I had been in practice for 12 years, and my brother had died about my 6th year. Young, he was like 41 when he died.
He was very young, as I recall.
And so when I was 31 or thereabouts, you know, my brother died, and so I had his practice and my practice, and so I was
very busy.
I had 3 or 4 other people working in the office, but I was too busy, but I was, you know, thought I was capable of doing anything at that point. And so I'd go from trial to trial and do the transactional work and so on and so forth. And when I became a judge, I was amazed at how few trials there was in Maine, jury trials.
Right.
There was like 85 or something. And I was doing probably 20 jury trials a year, civil jury trials.
You were handling a quarter of the jury trials.
Yeah. And so I hadn't ever thought of being a judge, but I'd thought I'm not sure that I want to do this until I'm 65 because I don't think I'll make it. But I hadn't really thought about it. And the true story is that I went over when Longley was the governor. I got appointed to the State Employees Appeals Board, which was my first experience at sort of judging. And I went over for a hearing, and on the way by the governor's office, his chief counsel said, "Dan, the governor's appointing some Superior Court judges. Are you interested?" And I thought, well, I was only 37, and my family was young, and I thought, well, there's probably going to be an interview because someone in my office had become a district court judge, and Jessie Gunther, she was like 27.
That's right.
She was the youngest thing around. And I thought, well, there'll be an interview. So I thought, yeah, I'd be interested in talking about it. And I went to the hearing. It was like 1 o'clock. And at 4 o'clock, I got a note saying, when you get done, come by the governor's office. And we didn't get done. And then about 5 o'clock, I got a note that said, come to the governor's office. And I went down, and as I walked in, the nominations were hung on the wall outside the office.
That's right.
And there was my nomination.
Surprise!
And I went in, and the governor said, "Oh, Dan," and I never had met him before, but he knew my brother. And he said, "Dan, I'm so pleased." And I said, "Well, I am kind of young." And he said, "Well, yeah, many years of experience, or many years of service. This is wonderful." George would be my brother. He said, "George would be very happy with this." And I said, "Well, thank you, sir." And that was it.
That was it.
That was it. So my wife heard about it on the 5:30 Maine Things Considered, and the people in my office. You know, I had 4 other
that's
lawyers.
Right.
So when I went in the next morning, they said, "Why didn't you tell us?" And I said, "I didn't know." Oh, okay.
Happened that fast.
Yeah, it happened that fast.
That transition from advocacy to judging is not always easy for some people. You were immediately identified as a great judge. You and I were both on the bench at a time when one of our beloved colleagues, didn't actually make it from advocacy to neutrality and really struggled on the Superior Court, not being the attorney for one side or another.
Yeah.
It's clear that it is not a simple thing to make that transition. All of a sudden, you went from just flat out busy advocate to being on the bench. How was the transition for you?
In retrospect, I think that I had having tried a lot of cases, I knew what good judges were, and they were not the advocates. They were people who judges basically keep quiet and rule on them.
Right.
Rule on the objections as they come along. So I never had the tendency. I wanted the attorneys to tell me what this case was about and the witnesses. I didn't want to say, "Isn't this case?"
Yep.
And because I knew that the attorneys knew more about the case than I would ever know about the case. And so I didn't have any trouble at all in being quiet. And the only time that I broke that was if I always used to, as judge, be a little concerned if we were not using the jury effectively. And so if there was some downtime, I would talk to the jury, but not about the case, but about something. And that was the only time I did that.
The transition was very smooth into...
It was easy for me to do that. I say this, the first trial I did, at that time they didn't assign you to your own county where you'd been practicing. So they assigned me, my first term was in Aroostook County, which is where I knew everybody. So the defendants and everybody else.
Good to see you again. Yes. Yes.
Yeah, Danny. One of the guys said, "Danny."
No.
So, the first case that I tried, obviously you're a little unfamiliar with it, and it was a case involving arson claim against a girlfriend who had got mad and burned her husband's or her boyfriend's belongings out in the dooryard. And they charged her with arson. Being tried, jury waived. So I went through, I was very careful in ruling on everything and following the procedure. And they got done, final argument, and I thought, wow. So I said, "I'll take a brief recess." And I stepped out back and I sat down in the judge's chambers and I thought, well, where is it? Where does this come from? God isn't speaking to me at the moment. It doesn't tell me what to do. And
exactly.
So I sat there and thought for 10 minutes and came to a conclusion and went back in and announced it. But I never had any problem with making decisions. I mean, sometimes they were difficult, but I never...
Those first jury waived trials where you've got to, here it comes.
I was usually
decisive?
Decisive and confident that I was doing the best I could.
Yeah.
Going back to the advocacy, where I did lapse into a bit of advocacy was I liked doing motion days because you'd have like 85 motions in Kennebec County on Fridays.
That's right.
And there you could beat it around with the attorneys, and insert, well, aren't you wrong to focus on this?
Right.
So that gave me my advocacy.
I think that's where I first saw you. You were on the bench as I was really getting into trial practice in the Attorney General's office. It was, and you, and then occasionally Don Alexander, which taught me that judges have very different styles.
Oh yeah, yeah.
But the best thing about those motion days, which I think attorneys today miss, if you were a new attorney, you could just go and sit through a motion day and watch really good lawyers.
Yeah.
You could figure out what not to do and how to make a good argument. It was a full class in how to practice law.
And fast.
You had to stay with it really fast.
Yeah.
My famous story with Dawn, I thought I was going to appear in front of you. They handed me a file. I stayed up for 2 days running. I knew everything in the file. When I walked into the courtroom, it was Don Alexander, who I didn't know. He said, "Where's the state?" And that's me.
Yeah.
I stood up and he said, "You lose. Next case?"
Yeah, yeah.
It was a whole different approach but you learn to work with the different judges.
Right.
Very, very different styles. So you were on the trial court for a while
4 years.
before you went to the law court. Who appointed you to the law court?
Joe Brennan.
There you go.
Yeah.
Okay. And when you went to the court, the chief was?
Vincent.
Vincent had taken over from Williamson at that point?
Yes. When Vincent became Chief Justice the day I became a Superior Court Justice. And so by the time,
okay.
4 years later when I went
So
to
he
the
had been
Supreme
there for a
Court,
while.
He'd been there 4 years, yeah.
And you sat with a very interesting group of colleagues over the early period of time. You became chief in 92?
Right.
92, and then I came to the law court in 97. So my experience in the courts was only Chief Justice McCusick, and then you were the chief for most of the time that I was appearing. You had about 4 years to get ready to be chief. Were you surprised to be appointed chief? Did you want that position?
I was on the Supreme Court 10 years.
10 years, okay. 10 years.
Yeah. I had no idea whether I had a chance for it or not, because you don't lobby for those things or even discuss it. But I had sort of decided that I was 51, and I naively thought I could go back to practicing law, which isn't true. Judging is a form of brain injury that disables you from practicing law.
That's true. That's a very good way to put it.
Yeah, but I indulged in that assumption, and I thought, I'm going to stay on the court. I had been there long enough. You know, I'd been 14 years as a judge. I thought, I'd like to do something different. I would really be interested in being Chief Justice because of the administrative part of it, which was critical of how it was going at the time. And so I thought, well, I'll stick around and just see how it goes, because Joe Brennan was running for office again as governor, and Jock McKernan was the other one. And I thought, I'm not sure which one I'd be better off with, but I know them both, and so I'll stick around and see. And I had no idea that whether I was even would even be considered or not. But as it turned out, one day I got a call from a reporter that says, rumor has it that you're being considered for the Chief Justiceship. Do you have any comment? And I said, no.
No.
But I wanted to say, where did you hear that?
Sources, please.
That was sort of a trial balloon as to my name, I guess.
And so you came in 92.
Right.
A lot was happening in courts across the country. You probably, as people have looked back on Maine's court and the evolution of appellate courts, you really picked up the leadership at a critical point where Supreme Courts everywhere were really beginning to be much more involved in how the state courts were administered, instead of just, as you used to say, waiting until the war was over and coming down and shooting the wounded.
Yeah, that's right.
There was much more administration. There were new cases. There were new causes of action. The district courts were kind of getting flooded with child protective cases and domestic violence, and the Supreme Court's caseload was growing, and was very slow.
The other thing that was happening was that year was the year where the state revenues throughout the United States dropped precipitously.
Like a stone.
And the entire state judicial budget at that time, including payment for assigned counsel for criminal cases and, the civil cases, was $32 million. That was the annual budget. And in that first year that I was Chief Justice, we went through 3 budget cuts, I believe, 2 anyways, and we were reduced to $27 million.
Good Lord.
Yeah.
$5 million out of the entire budget?
During the year. And we had a total in all courts of something like 52 judges, and we were carrying 5 vacancies. So in addition to everything else,
You had to deal with the vacancies in the trial court.
And I think it was that year, or if not, it was the second year, where I wrote to all of our suppliers, fuel oil, whatever we did, and said, we have run out of money. This was in like the 3rd quarter. We have run out of money, and we will have no more money to pay for anything until the end of the 4th quarter.
You have to wait till the end of June?
You have to wait till the end of June to get paid, and they all waited.
So you actually had to write
I did.
to the contractors of the court to say we've run out.
I only did it because I wanted them to keep delivering stuff. But yeah,
Good Lord.
Yeah. No, we were as close to being in bankruptcy as you could be.
Oh, wow.
And the National Center for State Courts came out with a publication about how courts were being hit, and they identified right in the lead that Maine was the hardest hit of all.
Oh, man.
And we were. When I was appointed, it was recognized that this was going to be a tough time. And one of the legislators said that I was the right guy because I was not committed to the status quo.
Which like meant being able to pay the bills?
Yeah, like being able to pay the bills. And so it was a...
Did you know what you were getting into when you went into the position?
I did, because there'd been some cuts before. They would send out a notice to everybody and say, please deduct 10% from your budget.
Oh, God.
And you tell us how you want to do it. And most of the organizations would say, well, we'll close the Washington Monument or something, close the music department at the school.
Right.
So if you're going to do it, you got to really say where you can do it. And it was painful, but you have to leave vacancies. And you may remember that we also did no judicial education.
Right. Oh, right.
Cut it out, even for orientation for new judges, which didn't bother me because I never had any orientation anyway.
Not a bit.
I got a yellow tablet and sent to Holton.
Go that way.
Whole court.
It's right there, up the interstate.
Yeah, you know the way up.
Yeah,
so, yeah.
Just go on up.
Go up and
That's fascinating.
Yeah.
I came onto the district court in 1990, and they did the same thing with me. They said, welcome to the court. Your first month is in Aroostook County.
Yeah.
This is for your own sake, because we want you to make all your mistakes far from home. And I said, training? How do I do the job? He said, you'll figure it out. You're a good attorney. And I did exactly the same thing. What I remember is when I finally figured out what I was doing, and I would call other district court judges, they were just mad all the time because things that had been available to them
were no longer available.
Judicial education, conferences, clerks in some instances.
Yeah.
We
were operating with. We weren't filling positions. There was actually a freeze on replacing. So if you
so if anybody retired or got sick,
you lost that one. Yeah.
Wow. What did you do during that period of time about court-appointed counsel? That used to eat the lunch of the court's budget. So did you have to send the same letter to the bar?
I sent the same letter to the bar saying we will not be paying bills until the end of the quarter. And I got some letters back saying, oh, I'm not doing any of that. I think it was actually only like 2 or 3 of those.
And most of the rest of them hung in.
Most of them hung in, and we didn't have any. What we did do at that particular point in time was we tried, as an experiment, contracting with a group of lawyers in
Right.
Skowhegan in Somerset County to handle it. And
That experiment worked really well,
yeah, it did.
and we were never able to duplicate it anywhere else.
I always thought we'll never be able to do it statewide.
Right.
But it, just in case, because Washington County was so scarce of attorneys that I thought that could, all of a sudden we'd have to do
Right.
that.
Right.
So it was sort of a pilot, and it was a successful pilot. But
it turns out that it was successful because the lawyers who did it were really had a great approach to working together, dealing with conflicts, and stepping up when they, and that continued through all the time that I was chief. They did a wonderful job, but we tried in several other regions and never could make it work.
No.
But the budget eventually came back a little bit.
I can't remember what the budget was when I left 10 years later, but it was probably not anything except and most of it, the addition was new courthouses that had been built and were being built into the budget as we went along.
Right.
I think it was up into the 40 million. And
it was around, yeah, and as I was leaving, it was around 50 million for.
But that's without court-appointed counsel.
We did manage to make sure that
we
inappropriate placement was fixed.
Our budget when I began was, all other included court-appointed counsel and everything else, judicial education, travel, everything. The all other was like 15 million of the total of 32 million. Court-appointed counsel was, my memory is, it was sort of like 8 or 9 million. So it was the major thing in all other, and if you overspent on that, then you were done. With
absolutely
everything.
Ate your lunch.
There's no other money.
That's right.
Yeah.
So we'd had some conversations about trying to, and it was, judges were actually making decisions about what defense attorneys had available to them for investigators and not making decisions with regard to the prosecutors. All of that was tough. Bob Clifford really took that one for us and did a great job. As you look back, people ask me all the time, what was your favorite case? And of course, you don't have a favorite case. Every case is important to the parties when you do it. But you were involved in several cases that had long-term effect. You and I talked about Brooke earlier, about the referee case. Tell me how it came to be that you were on the appellate panel reviewing a decision you had made.
When you're on Superior Court, you handle a high volume of material, so you don't immediately recognize these things. This was a simple case where the attorneys came in on, I've forgotten exactly what the subject was.
It was a land use issue.
And the attorney said, Your Honor, we'd like to refer this to a referee, and we're prepared to pay for the cost of it, the reference. I had more cases than I knew what to do with, so I said, give me the order and I'll sign it. You want to pay for the referee? Go ahead. So the referee rendered a decision, and then they appealed it. The case got assigned to me in advance of anybody looking at it, because they just, as you know.
Yes,
yes. So I didn't really even look at it until we were close to hearing it. And then as I got in there, I looked at the record and I said, holy smokes, I was I was the one who signed this. And it wasn't being appealed on the basis that this shouldn't have been referenced. It was being appealed as though it were a Superior Court decision. So I went to see Vincent, who was the Chief Justice at the time, and I said, I probably shouldn't be on this case because I'm the guy who did that. And looking at it, it makes no sense. This should never have been referred. It was a record review.
Right.
And the Superior Court judge could have done it. And I would happen to be the Superior Court judge. Vincent and another judge was sitting in with this, David Roberts. And they said, well, that's okay. You can write that opinion. You can be critical of your own work, because we're going to say that this should never have been referred, and
Right.
the
It
result
was really an administrative
it was an administrative
signature.
thing, yeah. So I thought, well, that's pretty good.
You
One
can
of my
reverse
first
yourself.
decisions is I'm writing, overruling myself.
It's a fascinating case. And
That's
of
the only
course,
time that ever happened.
well, this is good. This is good. So let's talk for just a minute about Bell versus the town of Wells. So you were, so many things came out of that case. That is the case in which the dispute over the public's access to the intertidal zone really got brought all together at the Maine Supreme Judicial Court, and the court split 4-3.
Right.
You wrote what I have frequently written was a brilliant dissent, but it did not capture those in the majority.
Right.
And as a result of that case, or at least this is how I understand it, so you've got to tell me if I know this correctly, the legislature ultimately was about to impose upon the court an ethics set of rules, and the court said, we'll do it. We will control our own ethics rules. But there was an allegation that the 4 justices who were in the majority, which limited the public's access, all had waterfront property, and the 3 justices who dissented did not have waterfront property. So I know neither one of us can talk a lot about what went on behind the scenes. Were you surprised at how the legislature responded to the decision?
No, it didn't. They, in essence, said you have to file a report of your real estate holdings, and that was fine with me. I would be happy to do that.
Right.
I filed the first report that I filed. I had a bunch of woodlots, and none of them were particularly valuable, but some up in the county and some around Augusta. And I don't mean a bunch. I had 3 or 4. And Bruce Chandler, who was a Superior Court judge when we first did that, he said, Dan, I saw your public disclosure of your holdings. He said, pretty impressive. You have a lot of real estate. And then I realized that I didn't know where any of these places were.
Not that impressive after a while.
Parham, Maine.
Parham. There you go.
Yeah. So it didn't. I didn't take offense at the legislature doing that. And actually, I can say that never was there any discussion among us as to who had property on the ocean and who didn't. And it never really occurred to me, and I was surprised when it finally came out that, wow, that's strange. Bob Clifford didn't have oceanfront property, but he had 3 tiers back from Pine Point Beach.
Right.
He had a summer place.
Right.
So I don't think it played much of a role in it. It's an interesting problem because it was essentially custom becoming law in Massachusetts Bay Colony.
Right.
And as I said in my dissent, the only thing I remember about it is I said, it's unusual to have a case of first impression involving an ordinance that was created 400 years ago. I mean, first impression 400 years ago.
Yeah.
There's something going on.
Something's wrong here.
And the history was sort of interesting.
It's a fascinating issue, and it has continued in the courts.
Yeah, and there's a Williams Mystic is a program run in Mystic, Connecticut by Williams College, I believe. And Derek Langhauser has participated there as a sort of an instructor, and they use Bell as a basis for a moot court among the students. And I went down several times and sat in on a moot court with the students arguing the
That's
case.
great.
Yeah, and it's been done. I think they've done it every year for at least 20 plus years.
It's a wonderful case, interweaving history and then current issues. So we have a little bit of time left, and I want to ask you some questions about the fall of 2001.
Oh,
So first, there's humor around this, and it was not funny, but we were in session when the first plane went into the towers.
that's right.
And our court officer, you may remember Harry Keklegian, remember Harry
Yeah,
the horse,
Harry the horse.
stormed into our chambers where no one came in when we were in discussion after a case and said, tourists have taken over the Twin Towers. And you said, Harry, tourists have not taken over the Twin Towers. Go find out what's actually happening. And he came back a little while later and said, terrorists. Yeah. I got it wrong. It's terrorists, not tourists. And it was a very frightening day. We had a lot of people who wanted us to close the courts, and eventually I think we did that. So fast forward 2 or 3 weeks, I think, you put out the word to all of us on the court that you wanted a conference call. We didn't have Zoom then.
Right.
So all of us in Portland, there were, I think 5 of us were in Portland that day, gathered around a speakerphone. You were in Augusta. I think Justice Rudman was in, Justice Rudman and Meade were both in Bangor. So we're all on a conference call. And you said, good morning. I figured it was a caseload issue. You know, we were all getting ready to figure out what to do next. And you said, I'm calling to tell you that I have resigned as Justice of the Supreme Judicial Court of the great state of Maine. Silence in the room, and someone, probably me, because I was always the sort of the loudest mouth, said, why? And you said, well, I can't talk to you about anything, but it's been lovely to talk to you this morning. Goodbye. And you hung up. Do you remember that phone call?
I remember the phone call. I don't remember.
It was very interesting because you were very clear that you, as of that moment in time, you had resigned from the court, and you could not talk to us about what you were about to do. And we all sat down and said, oh my God, he's dying. That was the very first thing that came to everybody. What could it possibly, he looked so healthy. And then, of course, we learned shortly thereafter that you were running for governor.
Right.
That was an amazing transition. Yeah. Tell us a little bit about what it was like to run for office after years of being a neutral jurist when people would say, what's your position on X?
Oh, it was awful, which I learned.
It was awful.
I had always recognized that I wasn't capable of being a politician, and that the only way I could ever have a public office that was elected was by acclamation, not by running. But in retrospect, I realized that 9/11 actually had a pretty powerful influence on me in that regard, because I remember this Susan Calkins, who was on the court, was sitting out on a case, and she came down and said, oh, they've crashed into the towers and people are jumping out,
right,
burning and all that. And then we were hearing cases, and the question came in, what are we going to do about closing the courts? And I said, have they closed the State House? And they said no, and I said, well, we'll leave it open. And then one of the employees filed a complaint for a union violation or something. Right. That sort of upset me a little bit. I thought, this is a time of national tragedy, and I said, we're not going to close the courts, but if anyone feels that they're so disconcerted by it, they're free to go home.
Right.
And that was challenged, and I thought that. But the truth of it was, I had been contemplating getting done before. By that time, I'd been on the Supreme Court 20 years. I'd been a judge for 24 years, and I was waiting for something new. trying to find out what I was going to do when I grew up,
Yeah.
and I hadn't found it yet. So I thought, this is a time. This is a time when Maine faces a lot of tough issues, and I would never reveal that I was not going to run for 2 terms if I were governor, but I had no intention of doing it. I thought one term, and you're going to have to do a lot of things that are unpopular, and so you won't be loved at the end of the term. You'll be, but you hopefully will have cured some of the endemic problems. So that was fine, but then I bumped right into what I knew was that I really don't have what it takes to be a politician that goes around and talks to people about voting or giving you money. I can't ask people for money. When I was in high school or grade school, there used to be selling magazine subscriptions, and I would go home and sell one to my mother, and then I'd go to a neighbor and say, "You don't want to buy a magazine subscription, do you?" And they'd say, "No."
No.
I'd say, okay. So I wasn't, that bothered me to do that. And then I met the party that I was running under, and they had changed in the 25 years that I'd been away from politics. I had never been involved in politics, but the leadership of the Republican Party was a very different animal 25 years after I had been familiar with it just from hanging around the Capitol. I got the sense as I was talking to people that I knew what they wanted me to say, but I wasn't prepared to say it. And it was just, in order to be appealing to people, you had to say things that you didn't believe, and I wasn't going to do that. So I thought, this is not for me, and I'll cut my thing right now. And I had no idea what I was going to do, but as it turned out, that led to a 20-plus year career of arbitration and mediation, which was really one of the more satisfying things that I've ever done. I mean, the best job I ever had was Chief Justice, but the arbitrator in a number of states and a few international arbitrations and a ton of work. I did more work in Puerto Rico than I did anyplace else, which in the wintertime is not a bad assignment.
Not a bad assignment.
They once called me and said, "Could you do a 3-week arbitration, and we'd like to do 1 week in January, 1 week in February, and 1 week in March?" I said, "How much will I have to pay you in order to do that?" And they said, "No, we'll pay you." So it turned out very well, because
And you've done a lot of very interesting. You were a master to the Amhite consent decree, which could have lasted several more lifetimes, I fear.
Yeah.
You were involved in the horrible tragedy in Lewiston.
Yeah, that was an interesting experience.
Let me slide off the serious topics for a minute and ask you to talk to us about your motorcycle. Now, you used to be seen, after you left being Chief Justice and I had the job, people used to ask me, when was I going to take a motorcycle and ride through the state of Maine like the Chief Justice of the state of Maine does. You used to ride through Maine with Angus on a regular occasion, and you did the same thing in Puerto Rico.
That's right. Well, actually, it's how I got the work in Puerto Rico. There was a Puerto Rican judge who was appointed to the U.S. District Court, and he went to judges school, which the feds have, with Mort Brody. And he said, "I'd love to come to Maine and ride motorcycles." He's a motorcyclist. And Mort said, "Well, you want to get in touch with Dan Wathen, because he rides," and so on and so forth. So Jose Fuste came up and rode with us on a couple of things. So when I was no longer a judge, he said, "I'll put you on the list of arbitrators and mediators in Puerto Rico." And I said, "Oh, that'd be good." And I went and I did one case construction case, and there were 25 lawyers from a variety of firms, which covered most of the firms in San Juan.
Uh-huh.
And those 25 lawyers generated probably 150 cases over the year from
And
that
all
one.
because of a motorcycle.
All because of the motorcycle. So in terms of my post-judicial career, the most important thing was my motorcycle. I had had a motorcycle since I was 15 years old.
Do you still ride?
I sold it 3 years ago.
Ah,
When you become mature,
mature.
yeah,
Your balance.
your balance.
Yes.
Yeah, balance is not your friend. And on a motorcycle, that's pretty critical. So I thought, I'm not going to ride when I'm dumping. I never did dump it, but I didn't want to dump it in
Yeah.
parking lot or worse places. So I thought,
And our bones aren't what they used to be.
no.
That's when you become mature.
All right.
Is my memory correct? I have a memory of you riding up to the Viles estate where we had that wonderful granite table with your mom on the back of the motorcycle.
Yeah.
Did she ride with you?
She did. Every year she wanted one ride. She was in her 90s at that point. They covered it in the KJ, and her name is Wilda, or was Wilda, and they had a picture of her and me, and it said, "Wild Wilda goes for a ride." And yeah, I would pick her up at the. She was living at a home, St. Mark's Home for Women, which we used to call St. Mark's Home for Wayward Women. I would pick her up there. She'd get on the motorcycle. All the ladies would be out on the porch, and I'd take off roaring, and we'd just get around the corner, and she'd say, "Okay, now you can slow down."
Slow it down.
She liked to take off with a roar.
You got to keep your reputation
But
up.
every spring I had to give her a ride, so she was happy.
So that actually happened.
Yeah.
Now, is the granite table still on the Viles estate?
It's still there. JMG
Still used?
occupies that
Oh.
office now.
Well, that's
And
good.
that table is a beautiful thing.
My last question is, as you know, we will be posting all of these interviews on the law school's website, so people can go to them and see all the amazing things that you've done, how your career worked. What advice do you have for people who are just starting out in the law today in this contentious and somewhat polarized environment? Any good advice for new lawyers?
I guess my pitch would be, don't confine yourself. Be open to things that come along. Because I never planned anything. The only thing that I ever planned was running for governor, which was a total colossal mistake. I never planned anything. Something just would come along, like the appointments to the court came along. I had no part in it. It was, all of a sudden, would you be interested? Yes.
Yes.
And so be open. And the thing that I liked about practicing law was your clients really brought the issues to you, and you have to be open to what they would do, what they brought. And I know many lawyers whose entire career has developed out of one client coming with a particular kind of work, and that puts them into that field. The nice thing about the law is you get exposed to a wide variety of things and remain open to them, and you will eventually find something that really is your area. You find your niche, and that's what I found in law school. I mean, I had never been a great student. I pulled it together enough to get to law school. The first year I was in law school, I thought I could get tossed out of here. I mean, I've flunked out of college twice, so I know how to do it.
Yeah,
And
I know how to do it.
I went in to get the grades from Dean Godfrey, and he said, "Dan, you got the highest grade in every class." I thought, holy smoke, what's wrong with the other people? So remain open to the great possibility that you'll strike something that really shakes you. And the law is wonderful because it is so broad and so wide.
Great advice. Thank you so much for joining us here today. I'm really grateful for your time.
Well, thank you.
It's been wonderful.
Thank you for inviting me.